Hello, my name is Olurotimi Osha. I'm continuing with my discussion on mental health law. Of course, I started the discussion especially because of the um, the raising of the 25th Amendment. Of course, the American public has been up in arms, and you know, you know. Clamoring that the 25th Amendment be invoked by the Vice President and the Cabinet to remove the President from office. Of course, that happened after the President made incendiary remarks to annihilate the Iranian civilization. And of course, I've done videos explaining the 25th Amendment, so I'm not going to do that now. So I'm going to get into cases that establish standards regarding mental health. Now, of course, the fourth section of the 25th Amendment, which allows the removal of a president due to incapacity to fulfill the powers and duties of his office, uh, the you know it's never been invoked before, right? And by the way, it allows the president to also counter by issuing a declaration, that's an affidavit, to the Senate um, president, the president pro tempore of the Senate, and the Speaker of the House. Um, and then in the event that happens, and then that's it also gives another opportunity for the vice president to counter again with another declaration, and then finally the two-thirds of both houses of Congress has to decide, right? Uh, no doubt, since this has never been invoked before, it would allow the president to uh, take the matter to the Supreme Court because we will be facing a constitutional crisis. The Supreme Court has never opined on the 25th Amendment. Of course, it was just ratified in 1967. And of course, the Supreme Court does not have an advisory role, right? They decide cases and controversies. That means there must be an active dispute before them. So hopefully, maybe we'll get to see a dispute, but it's in Vice President J.D. Vance's court, right? He's the one who has to initiate this issue of invoking the fourth section of the 25th Amendment to remove the president due to incapacity. And their argument would be that, well, he's not suffered a stroke or anything like that, right? He doesn't have a physical disability, so they'll be claiming that he has some kind of mental capacity. And what the media has been saying, well, he's crazy, that he's nuts, his mental acuity, he's nuts and all that. However, it will be clear if it makes it to the Supreme Court that the Supreme Court would need um, they would need not not hearsay, not slander or libel um, or gossip or ad hominems of the public or the president's detractors. It would be clear that the Supreme Court would need the um, the opinion of experts, meaning psychiatrists and psychologists. They would need that. So and that's where I'm getting into this case, Addington versus Texas of 19. It was decided by the Supreme Court in 1979, and this case established, the Supreme Court established that, well, if you're going to determine on whether a defendant is, if you're petitioning for someone's commitment, right, indefinite commitment for mental health treatment, right, then the petitioner has to show that the person is mentally ill. They're trying to show that the person is mentally ill and they're dangerous, right, and so should be committed for an indefinite period. So the Supreme Court established that the uh, the opinion of experts, you know, uh, must be presented to trial of facts. Trial of facts would need the opinion of experts. That includes psychiatrists and psychologists, right? And of course, the burden of proof would be on the petitioners. So it wouldn't be enough for J.D. Vance to just say, well, President Trump is nuts, he's crazy, because Megyn Kelly says so, or Candace Owens says so, or Tucker Carlson says so, or the American public says so, and everybody is saying so. No, it would have to be actual psychologists and psychiatrists who've actually evaluated him. They've evaluated him and they made that determination, and they have to give some kind of diagnosis, right, of a mental illness, whether it's bipolar disorder or schizophrenia or something, something that renders him unable to fulfill his role as functionary, and he would need institutionalization, or since he's wealthy, he could be confined to his home and receive private treatment, right? Wealthy people have that ability. So it's this case, Addington versus Texas, that decided that. So let me get into it. Addington versus Texas. So Frank Addington was he had been before he was arrested. He was arrested for making an assault threat against his mother, and however, his mother had already gone and filed a petition in court, right, to have him committed civilly, right? Again, before the standards were set that before somebody can be committed into a psychiatric hospital, it's their constitutional right, the 14th Amendment right, to have due process. So they're entitled to a public trial, a trial by jury, right, before that can happen. So she filed a petition against him. And by the way, Frank Addington already had a history of psychiatric hospitalizations, right, due to emotional and mental disturbance. He already had a long history, recorded history of prior hospitalizations for psychiatric problems. So the judge had given juries instructions that they should use the standard of clear, unequivocal and convincing evidence, right? So that's a jury instructions which the judge gave. Remember, their standards. The civil standard is a lower standard. So the standard the judge actually gave was higher than the normal civil standard. The normal civil standard is, in a civil case, would be a preponderance of the evidence, right? So that's a lower standard, a preponderance of the evidence. It doesn't have to be a high standard. Preponderance of the evidence, say, assume 51 to 49%, right? So just preponderance, just narrowly scrapes. It doesn't have to be clear and convincing. So clear and convincing is a higher standard. So that's the jury instructions which the judge gave. So the jury found that he was mentally ill, and for his welfare and the welfare of others, that just means that he's dangerous, right? The jury thought he was dangerous and that he had a mental illness and that he should be committed for an indefinite period. So he was committed to the Austin State Hospital, a psychiatric hospital. However, he filed an appeal. That's Addington. He filed an appeal to the Court of Appeals, saying that the judge gave an improper jury instruction, that it should have been a higher standard, that the judge should have given a beyond a reasonable doubt standard. Remember, the beyond a reasonable doubt standard, that's a standard that's used for criminal cases, because the gravity of criminal cases, because it's your life, your liberty, that's what's at stake, something very important, and more important than civil cases, just money. You're not losing your freedom, but in criminal cases you can lose your life, your limb, your freedom, right? You could be incarcerated. So we have the highest standard of proof, and it's a state, the petitioner, that has the highest standard of proof in a criminal case, right? The plaintiff, that's a state, and that's beyond a reasonable doubt. So the Court of Appeals decided in Addington's favor, and then they reversed the lower court. The Court of Appeals, they said what standard Addington thought that the standard of beyond a reasonable doubt was what was required, right? And the Court of Appeals agreed with him and reversed the case. However, it was taken all the way to the Texas Supreme Court. And guess what the Texas Supreme Court did? The Texas Supreme Court reversed, right, overruled the Court of Appeals, and even now gave the lowest standard, the normal standard for a civil case, because the Court of Appeals thought, well, this is a civil commitment matter. It's a civil case, right? And it should have the normal civil burden of proof, the normal burden of proof for a civil case, and that is preponderance of the evidence. So you could see the law that even judges make mistakes, right? Judges make mistakes, apart from maybe judges acting, maliciously or malevolently, but judges do make mistakes, right? You can see that the law is not science. It's not scientific. It's subjective. So you can see within the state, how many different courts? 3 different courts have 3 different opinions. The lowest court thought, well, clear, unequivocal, and convincing evidence should be the burden of proof. Court of Appeals thought differently. They said, well, the burden of proof standard should be beyond a reasonable doubt. And then the Supreme Court now even gave the worst decision. The Supreme Court said that the lowest standard is what's required for commitment, and that's the Supreme Court of Texas. They made the worst decision, right? They thought that it should be a preponderance of the evidence, right? The Supreme Court, right? They should be the pinnacle of logical reasoning, thinking, wisdom in the state of Texas, and they actually made the worst decision, right? So the lowest court actually made the right decision. The lowest court, it said, well, the standard should be clear, unequivocal, and convincing evidence, right? So you see 3 different decisions in the same state by 3 different levels, court levels, in one state. So eventually, the case was dismissed, but Addington was adamant, he was persistent, and he filed what's called a writ of certiorari. Writ of certiorari, you're asking the Supreme Court to review a matter, a state matter. So that's what's going on, and make a decision, right? Because it has constitutional implications, right? So remember, I'd done a video and I explained that in matters of public safety, health, right, and welfare, that's reserved to the state, right? That's from the 10th Amendment. The 10th Amendment says that powers not delegated to the federal government, to the United States federal government, national government, federal government, by the Constitution, or prohibited to the states, right, are reserved to the states respectively, or to the people. And so that means it's not delegated. It's just saying that, well, if the U.S. Constitution is silent, it hasn't said anything, and the U.S. Constitution doesn't say anything about public health, it doesn't say anything about public safety, it doesn't say anything about public health, that's health, that's what we're talking about, health, right? Medical health, it doesn't say anything about welfare, right? So it's reserved to the state. So that's within the state purview. Now, however, the federal government does still provide guidelines, right? Minimum standards too, because the fundamental liberty of American citizens are implicated. So there's a 14th Amendment due process implication, right? Because it has to do with if you're committing somebody, confining someone, you're depriving them of their fundamental rights to be free, right? Their freedoms, right? So it implicates a 14th Amendment, 14th Amendment rule, right? So And that's why it goes all the way to the Supreme Court, because they were dealing with the confinement, the taking away of the rights of the freedom for a citizen to be, the right of a citizen not to be confined, to be free. And that's where the Supreme Court then established the standard, and that's the standard we have. The Supreme Court, uh, declared that the standard should be above the normal civil standard of preponderance of the evidence, right? So that the standard should be clear and convincing evidence, right? Clear and convincing evidence. So that means the trial court got it right. But when the Supreme Court makes a decision, right, it now applies nationally, right? It becomes a rule, a national standard. And so every state has to abide by it, right? It becomes part of the Constitution, right? And that's why, they've interpreted how the laws should be obeyed, the rules should be applied. So, and their reasoning was also that it couldn't be beyond a reasonable doubt, because one, psychiatry is uncertain. It's uncertain. It's not a science, and it's very difficult. So, because it's not a science, that you can't ask for that strict level of beyond a reasonable doubt that you need for for a criminal case, right? But that because the stakes are very high, the stakes are very high, because it has to do with the gravity of the issue. That's you're taking away somebody's freedom. Still, you're taking away their freedom, even though you're not necessarily taking away their life or imprisoning them, but being forced to be confined to a state hospital, you're still taking away their freedom and their rights. So the stakes are much higher than a regular civil matter, right? So that's why they said the standard should be clear and convincing evidence. And then they also established that because it's a medical issue, that the issue of committing someone to receive treatment and for their welfare, or because they're dangerous, that they're mentally ill and they're dangerous. Remember, those two standards were established, that they have to be mentally ill. There has to be dangerousness, right? The person has to be dangerous, not just mentally ill. Of course, this was established in the case of this standard was established in the case of O'Connor versus Donaldson, right? That they have to be dangerous for you to be able to confine them. But the Supreme Court now established in this case, Addington versus Texas, that the petitioner would need the trier of facts, right? Because it's the burden of proof is on the petitioner, right? The way it works is that the defendant, the person who's the counterparty, is presumed to be accurate, that that they're the ones who are correct. So it's the petitioner, right, who's presenting facts to the trier of facts, right, the jury and the judge, as the case may be. They have to be the ones who prove that standard, right, the burden of proof, and provide that clear and convincing evidence. And one of the ways that they can do this is, in fact, that they're required. This is what the case established the requirement, that the trial of facts has to provide the opinion of experts, that's psychiatrists and psychologists, because it's a medical issue, right? It's a medical issue to determine if someone's mentally ill and they're dangerous to the public, right? That it's a medical issue, and so they need the opinion, they need the facts, the determination of experts, that's psychiatrists and psychologists, right? Not just hearsay, not just what people are saying, not just lay people. And the jury, the jury and lay people, they can't make that determination themselves at the trial of facts. But this is what the case of Addington versus Texas established. And so it's not sufficient for the public or the cabinet to just say, well, President Trump has lost his mind, he's crazy. It's not sufficient to do that. if there's a constitutional crisis and then it goes to the Supreme Court, the standard is that the Supreme Court would require some kind of assertion, determination from medical experts, as psychiatrists and psychologists, who would have to provide, a diagnosis, right, and show prove his incapacity. My name is Olurotimi Osha, and I will keep you posted. Thank you.